Good evening, guys. I am Rival Kyle Escobalida, and I am here to discuss to you the topic that is all about the criminal procedure and court testimony, specifically the pre-trial. So, first and foremost, what is pre-trial? Under Section 1, the pre-trial mandatory in criminal cases, it is said that in all criminal cases cognizable by the Sandigan Bayan, Regional Trial Court, Metropolitan Trial Court, Municipal Trial Court in cities, Municipal Trial Court, and Municipal Trial Circuit Trial Court. The court shall, after arraignment and within 30 days from the date the court acquires jurisdiction over the person of the accused, unless a shorter period is provided for in special laws or circulars or of the Supreme Court, order a pretrial conference to consider the following. So in pretrial, it is a process which is mandatory in criminal cases. Uh, Kapag may criminal case, which meaning to say may pretrial. Saan nga ba nagaganap ang pretrial? It is stated in Section 1, which was I said before, Sandigan Bayan sa Regional Trial Court, Metropolitan Trial Court, Municipal Trial Court located in cities, Municipal Trial Court, and Municipal Circuit Trial Court. So, the second one, what is the purpose of pre-trial? Bakit nga ba ginagawa ang pre-trial? So, the first one is the plea bargaining, wherein plea bargaining offers a plea bargaining must be initiated in writing by way of a formal written motion filed by the accused in court. The lesser offense with the accused proposed to plead guilty to must necessarily be included in the offense charged. So the second one and the purpose of pre-trial is the stipulation of facts. So the stipulation of facts means that the rules of court mandate parties in a criminal case to stipulate facts, wherein once they have validly voluntarily signed the stipulations, the accused and their counsels may not set this aside on the mere pretext that they may be placed at a disadvantage during the trial. So the third one is the marking for identification of evidence, the parties. The fourth one, waiver of objections and admissibility of evidence. The uh, the next to the last is the modification of the order of trial of the accused if the accused admits the charge but interposes a lawful offense. So the last one is the such other matters will promote a fair and expeditious trial. Uh, the Another thing, the purpose of pre-trial to conduct preliminary investigation is an inquiry or proceeding to determine whether there is a sufficient ground to engender a well-founded belief that a crime has been committed and the respondent is probably guilty thereof and should be held for a trial. So, what is a trial? The trial is a structured process where the facts of case are presented to a jury, and they decide if the defendant is guilty or not guilty of the charge offered. During the trial, the prosecutor uses witnesses and evidence to prove to the jury that the defendant is committed the crime. So, a question arises that what will be the effect of failure to attend the pre-trial? So, for failure to file the pre-trial brief shall have the same effect as failure to appear at the pre-trial. Hence, the failure of a party to appear at pre-trial has adverse consequences. Consequences. If the absent party is the plaintiff, then he may be declared non-suited and this case is dismissed. If the absent party is the defendant, then the plaintiff may be allowed to present his evidence ex parte. and the court to render judgment on the basis thereof. By way of exception, the non-appearance of a party and counsel may be may be excused if one valid cause is shown, or two, there is an appearance of representative on behalf of a party fully authorized in writing to enter into an amicable settlement, to submit to alternative modes of dispute resolution, and to enter stipulations of or admissions of facts and documents. What constitutes a valid cause is subject to the court's sound discretion, and the exercise of such discretion shall not be disturbed except cases of clear and manifest abuse. So, what will be the effect of failure to attend the trial? To failure to attend the trial, same goes with the pre-trial. If you do not show up for the trial, the plaintiff can ask for a default judgment against you as above. You will have missed your chance to tell your side of the claim to the judge. So that is all. Thank you.